afternoon, everyone, and welcome to our second video conference to talk about the issue that's on everybody's mind, that is the governor's proposal to abolish redevelopment in California. I'm John Shirey. I'm the executive director of the California Redevelopment Association. I want to introduce the people that are with me here today. First of all, on my right, I'm happy to have Chris McKenzie, who is the executive director of the League of California Cities, joining us today. And really, this is a joint conference between the League and CRA to cover this important topic. On my left is our general counsel and our legislative counsel, Brent Hawkins, who is with the firm of Best and Krieger. And then on my far left is David Jones, who is our head lobbyist and who has been in the thick of things ever since the governor's proposal was announced. What we want to try to do today is give you some initial information about the issue and what's going on. I want to ask Chris to make a few comments, and then most importantly, though, we want to take your questions. You've gotten some instructions there on how you can ask questions. You use the chat feature, which should be on the right side of your screen. And of course, you must be logged in as a user in order to be able to access that chat feature. We're going to run about an hour today. Hopefully, we'll be able to get in all the questions and answer those things that are on your mind. But that'll just depend on, of course, how many questions we get. First of all, I want to ask David Jones, our lobbyist, to tell you what went on today, what happened last Friday, and what we can expect over the next few days with respect to the legislature's consideration of this issue. David?
Thank you, John. As expected last Friday, both houses' budget committees completed their work and passed their versions of the governor's budget. The Assembly, in a slightly different version, voted to score the $1.7 billion that the governor is asking for. And they did it through a suggestion that there be changes made and reforms to redevelopment. So they did not vote, as the Senate did, to eliminate redevelopment. So Senate voted to score $1.7 billion, but also to completely eliminate redevelopment. The Assembly and Senate then named their budget conferees, and I'll tell you who those are. They met today. The budget conferees for the Senate are Senator Leno, Senator Huff, Senator Emerson, Senator Lowenthal, and Senator Negretti-McLeod. The Assembly budget conferees, and the one who will be chairing the conference committee is Assemblyman Blumenfeld. With him is Mr. Nielsen, Mr. Fuentes, Ms. Harkey, and Ms. Skinner. So they met today. They had their first initial overview of the budget conference committee, and they announced a very ambitious schedule that they're hoping to complete pretty much their work in the next 6 days. So they met today, had an initial overview. They did talk about realignment and redevelopment. They had a robust discussion about opening statements about redevelopment, and it obviously is the big hot topic for the conference committee. They're aiming at having completion of their task and having a product voted on by the full conference committee and put on the floor by early next week. So they're aiming on having something wrapped up in relatively short order. They are not meeting this afternoon. They're going to meet tomorrow morning at 11 and Friday at 10 o'clock. So we're going to be obviously very busy between now and then looking at the issues as they discuss them. So with that, I don't know if you want me to go over further.
That's fine, David. And you got updates this morning from both the League and from us urging you to contact those conferees, let them know our position on eliminating redevelopment, urge them not to do that, of course, and also you need to let your stakeholders know, those other beneficiaries of redevelopment in your community. They don't stay tuned to these kinds of things, and so you need to keep other people in business organizations, housing organizations, and so on, informed as to what's going on, and urge them to contact legislators as well. It's also a good idea to let your own legislator know what your position is. in addition to contacting the conferees. So now's the time to be making those calls. There's not time for letters. You need to be making calls and sending email messages, things that are going to get there rapidly. The last time we had one of these video conferences, we had hoped that we would be talking about the specific bill language that they were considering on this issue. Well, all this time has gone by and we still don't have bill language, and we thought that maybe by today we'd be able to explain that to you. Well, as luck would have it, we received word just a little bit ago that we're going to receive the bill language later this afternoon. I think it will be posted on the Department of Finance website, so all of you can look at it just as quickly as we can. We understand it's about 50 pages, so it's going to take us a while to do an analysis, but as soon as we do, we'll turn that around and get that back out to you. So bill language, not there. They voted on Friday without anything in front of them. That would be akin to your city council voting on an ordinance that had never been written, much less being in front of them, but that's the way the committees acted on Friday. So hopefully by the end of the day we'll know more about the specifics of the governor's proposal. Let me ask my colleague Chris McKenzie to say a few things and bring you up to date on some things that he's concerned about.
Thanks, John, and good afternoon, everybody. It's good to be with you. Just one little housekeeping note. I just wanted to share with you that if you weren't aware, we have some non-city officials, specifically some friends of ours in the news media with us today. So we just wanted to welcome them for this very important discussion. You know, as I look back on this, and I talked with the league board about it very recently, we really anticipated the fight that we're in right now back in 2009, the summer of 2009, in fact, when some of you joined us for a major summit where we looked at the state-local fiscal relationship and concluded our #1 priority had to be, once and for all, ending the state raids on local funds. There are many other reforms the state needs, but from a local government perspective, none was more important. We then worked with a number of partners, including the California Redevelopment Association, to draft what became Proposition 22. And Prop 22 provides incredibly important and incredibly powerful protections for the funds that the voters expect be spent at the local level. And then, as you know, in November of last year, that was approved by 61 to 39%, an overwhelming expression of the voters' desire to make sure local funds stayed at the local level. And just in case anybody has forgotten what the voters voted on, and they want to suggest, as some have in the state government, that they didn't know they were protecting redevelopment funds, let me read the ballot title to you. This is what the voters saw on the ballot. Prop 22 prohibits the state from borrowing or taking funds used for transportation, redevelopment, or local government projects and services. That was the ballot title written by then Attorney General Jerry Brown. Then it goes on to say further, prohibits the state, even during a period of fiscal hardship. Let me underscore that. Even during a period of fiscal hardship, from delaying the distribution of tax revenues for transportation, redevelopment, or local government projects and services. So it really was protection for a three-legged stool of local government revenues, transportation, redevelopment, and general local government revenues, including your local taxes, property taxes, sales taxes, etc. That's what the voters saw. That's what the voters voted on. The state legislative analyst acknowledged in its own analysis that this would prevent the state from raiding redevelopment funds. That was in the ballot labels or the ballot title and summary's fiscal note. It's incredibly important that we remember what the voters said. They said no more raids on local government, transportation, and redevelopment funds. We're now in the midst of a very, very critical fight. And I want to suggest to you that we need your help in actually helping the legislators respect and observe and carry out the will of the voters. Only 3 months ago, in your interactions with them, it's very, very important that we remind them, and we remind our critics, that they may not like what happened in November, but it happened, and it happened decisively. And the voters have said with great, great clarity what they expect to have done, and they, as you know, expect to have their actions respected. So we've prepared for this fight. That was our 4th ballot measure campaign. We know what is in Prop 22 and other parts of the Constitution. You're going to hear about that shortly. And we have to stand up and demand that the legislature and the governor respect what the voters have said. So with John, I'll turn it back to you and the next part of our program.
Okay, thanks, Chris. And I just want to add that it was heartening to hear this morning in the conference committee some legislators acknowledge what Chris just said. They acknowledged passage of Proposition 22 by a wide margin. They understood that the will of the people had been expressed through Proposition 22, and in fact they were saying to their colleagues it ought to be followed. So we know that the communications that you're sending and making with your legislators, they're getting through. People are hearing that. We're hearing some of your own comments in the words of legislators just today. Now let me stop there and start taking questions from all of you. Again, use the chat feature in order to send us your questions. I'll repeat them, and then one of us will take a crack at answering them. The first one says some cities are selling existing public assets to their RDAs, their redevelopment agencies, taking back an interest-bearing note for a long period of years. Will CRA agree to have these deals abrogated? I'm going to ask the lawyer on our bench here to take that question. Brent?
Okay. I'm aware that there are a number of these kinds of agreements that are being looked at by redevelopment agencies around the state. Without the precise language of the legislation in front of us, it's difficult to answer that question, and a lot of these other questions I'm sure we're going to get with a lot of confidence. I will tell you, first of all, that the summary of the governor's budget proposal that has been published states that they intend to honor existing obligations. They've been less than totally forthcoming about what they consider to be existing obligations. They have said that they will honor, for example, bond obligations and contractual obligations with third parties. They've also been fairly consistent in saying that if they have their way, that is, if the legislation that is passed reflects their intent, that it will not recognize or honor these kind of intramural agreements between cities and agencies. All of this, of course, presupposes that legislation is passed which eliminates redevelopment agencies. So I don't know how much more definite of an answer I can give than that. That agencies are looking at these. I think they need to be looked at on an individual basis based on what the situation is in your city. The administration is obviously hostile to these kinds of agreements. That doesn't necessarily mean that they will carry the day.
Okay, so that's one of those questions we can answer better after we see the bill language, and again, we expect that to be posted on the Department of Finance website later this afternoon. The next question says, will we be having an annual conference this year? Well, the answer to that is definitely yes. We're meeting March 30th through April 1st in San Jose. Obviously, registration is open. We have the program set. So despite the threat here to redevelopment, we're still going to have our annual conference, and hopefully we'll have some good news at the annual conference to celebrate, and I think Chris is going to try to be with us as well.
Absolutely.
Next question comes from, or said, will you have the opportunity, when will you have the opportunity, what is CRA's position on the 10 largest cities proposal to negotiate a resolution? I'm going to ask Chris if he would field that question. I'm sure others of you on this broadcast have heard about this other proposal.
Sure, thanks, John. I think it's a great question. You know, we really value all the ideas that are coming forth about how to address this question about how to deal with the governor's illegal proposal to abolish redevelopment agencies. I can tell you this: we know there's going to be there are proposals from those cities. There are other proposals that have come forward. We will probably see more of them over the next few days and weeks. Here's how we're going to evaluate them. Number one, we're going to ask whether they are constitutional, whether they're legal under Prop 22 and other parts of our Constitution. Number two, we're going to ask, do they subvert the will of the voters? That will that was so clearly expressed in November and by a 61 to 39% majority. And we're going to ask that any legislation and anything considered by the legislature respect the will of the voters. And finally, for those of you who are league members, you should know that because we didn't go into Proposition 22 without consulting our membership, it is such an important priority of the Board of Directors that the board has determined that any consideration of any proposal to change our position on protecting these revenues is one that's going to be made at the grassroots level. It will only be made by convening a special meeting of our General Assembly, the over 470 cities in the state and their representatives, and you will be asked to answer that question. Not the league staff, not the league board of directors, but the cities of the state.
Yeah, and let me just add to that I've had a few questions come to me, not today, but in the last few weeks that would indicate that some of you don't know that the league and CRA work closely together. We don't have different positions. We work together on these issues. Obviously, most of the members of the governing bodies of redevelopment agencies are elected officials who sit on city councils. We also, of course, have county agencies and county boards of supervisors sitting as agencies. So it would make little sense for somehow CRA to be in a different position than the league on a matter as critical as this one. So we do work closely together, and our position is not really any different. But let me go on to say that we've also been asked about so-called reforms to redevelopment. Both the league board and our board are willing to entertain reforms, things that have been criticized about redevelopment, things that we think can be corrected, things that don't have to end up in the category of abolishing redevelopment, but simply make it better for everyone. We have considered those proposals at the CRA Board of Directors, and when the time is right, we'll be talking with legislators about reform proposals. But that's not where we're at the moment. Where we're at the moment is the proposal is on the table to abolish us, not reform us, abolish us. That's the one that needs to be defeated or withdrawn in order for constructive talks to take place. Now let me go on to the next question. Does the CRA recommend that agencies lock up future TI with grant and cooperative agreements with their cities? How many have? This is a question I'm asked seemingly every day. Our position has not really changed from the beginning. We have said all along that if you have transactions that are in the pipeline, that are nearing completion, you need to go ahead and make extra efforts to get those done, to get those under contract or funds encumbered or whatever. We are not advocating that agencies take on new obligations without doing due diligence. There still is a responsibility on everyone's part out there to make sure that deals and transactions that are entered into are responsible and that are good for all parties. How many have done that? We don't know. We're not really tracking that. I think everybody needs to know that we're focused on defeating this proposal, and that's where we're spending all of our resources right now, and that's where you should be too. Next question. any indication about retroactivity should they go through with plans to eliminate RDA. There were a lot of rumors earlier in the month and in January about retroactive legislation. None of those rumors came true, but that's where we may as well just wait and see what the language that comes out today says. That'll answer questions that we don't have to speculate on what the governor's people may have in mind. Next question. Could Proposition 22 have been written in such a manner as to prevent the state from terminating redevelopment agencies? Well, I'm going to let either Brent or Chris respond to that one. Brent, why don't you go first?
Well, I think actually there are provisions of the Constitution that do prohibit the state from terminating redevelopment agencies, in particular Article 16, Section 16 of the Constitution, which establishes tax increment financing and requires tax increment to be paid to a special fund of a redevelopment agency, not to anybody else. And so I think actually the Constitution is already fairly clear on that.
Want to add anything, Chris?
No, I think that's exactly correct.
Well, let me also add that there appears to be a theory in the Capitol that by eliminating agencies, that means the state can take the money. And we're here to tell you that we think that's just flat wrong. That Proposition 22, more than anything, protects the money that goes to redevelopment agencies. And so by whatever means that the state may try to get around Proposition 22, we think it's very strong. And by eliminating agencies doesn't mean that they can take those funds. And after all, folks, it is about the money. It's not about the existence of the agencies. Next question, have the state audits of the RDA started yet? I think what the questioner is referring to there are the reviews, and I'm going to underscore the word review, being done by the State Controller's Office. 18 agencies were selected for these reviews. They are underway. Many of them are completed. We expect the controller to come out with some sort of report by mid-March. We're getting feedback from agencies that are undergoing those reviews. They're sending us copies of the draft reports that they're receiving. It seems to be going pretty well so far. Of course, we don't know what will come out in a final report. We'll share that with you as soon as we know what it is. Next question. If they, meaning the legislature, pass new legislation to eliminate redevelopment, how can it be overturned? Well, that's a legal question once again. Brent, you want to answer that?
Sure. If that were to happen, the League and CRA are prepared to initiate legal challenges in the courts to demonstrate that the provisions of the legislation are inconsistent with provisions of the Constitution. Of course, the legislature can pass laws, but those laws have to be consistent with the Constitution. Constitution is the supreme law, and we think, at least as we understand it, based on what we know about the governor's proposal right now, we think his proposal violates at least three provisions of the Constitution. The first, I've already mentioned, is Article 16, Section 16, which established tax increment financing and requires tax increment to be paid into the special fund of a redevelopment agency and used to repay indebtedness that is incurred by the redevelopment agency to carry out the redevelopment project. And we think the governor's proposal is inconsistent with that provision, that it has tax increment paid someplace else and for some other purpose. We all, as Chris has mentioned, we also think the governor's proposal is in conflict with Proposition 22. Proposition 22 says that the legislature cannot require a redevelopment agency to pay or otherwise transfer directly or indirectly its tax increment. And we think that What the legislature has done here is doing in 2 steps what can't be done in 1, and that's an indirect transfer. And finally, we think it also violates provisions of the contract clause of both the state and federal constitution, which prevent the legislature from enacting laws that inhibit or violate the obligation of contract. So those, I think, are the 3 principal constitutional objections that we have, and if necessary, we're prepared to file those actions and have court determine the matter.
Okay, great. Next question, given Proposition 22, why are the big cities willing to give up 22% of tax increment to the state? Chris, I'll let you field that one.
Thanks, John. I think the honest answer there is that we can't speak for those individual cities. I would underscore that it's our understanding that not all of them support that proposal, and that further study of it is underway. But what I can do is tell you that the League of California Cities, again, in the CRA, but speaking for the League, will review it and every other proposal for, number 1, its legality or its constitutionality. Number 2, whether it's consistent with the will of the voters, and we're urging the legislature to show that they respect what the voters did last November. And number 3, whether any proposal is approved by the League General Assembly. So I wouldn't presume to speak for those cities. They haven't shared their reasoning with us, but we're going to evaluate that proposal just like any other proposal.
Okay. And by the way, that 22% figure in there wouldn't be the latest version of that proposal, but nevertheless, the point is that it does propose transferring funds to the state for non-redevelopment purposes. Next, is there an anticipated outcome of the Budget Conference Committee meeting on Wednesday and Thursday? What happens after that? I'll let David field that. Actually, Conference Committee met today, will meet tomorrow and Friday.
Yes, well, as anticipated by the schedule that the chair laid out, is they're going to do what's called the first pass through the budget. So they're going to go through and look at all the items, make decisions on the easier ones that they can reconcile between the 2 houses, and generally leave the bigger decisions to next week. So basically, this is the first pass through. They'll clear out the underbrush of those decisions that are easier to make, less controversial. And it's anticipated that redevelopment, realignment, tax questions, those things will be left open. They hinted that this weekend they would not have hearings or meetings in public, that they would be working behind the scenes on potential compromises. But I think on this week, I think they're going to look to go through the budget once and regroup over the weekend and see where they are for next week. So this is a big window of opportunity in the next few days.
Okay, next question comes from Rob. Our CRA League working to empirically demonstrate that the governor's proposal will not actually yield $1.7 billion if existing RDA obligations are honored. A little background on this question for everyone in the broadcast. The governor's proposal suggested that for the first year, the budget year, after agencies are eliminated, there would be $1.9 billion left over after subtracting out existing obligations, $1.7 billion of which would be used for Medi-Cal and for trial courts, with $200 million being distributed to cities, counties, special districts, and schools. Several of you have posed the question, is that really a correct analysis? Well, first of all, we know that that analysis done by the Department of Finance used 3-year-old data. Everybody knows that in the last few years, tax increment has probably gone down because of diminished values in property. And so the question is, how much is really available? There have been various analyses done outside of state government suggesting that that number is a whole lot less than $1.7 billion, and we think they're right. We have not tried to somehow argue that issue because it suggests that we're willing to give up any money. We're not. we're not. As Chris has emphasized, this is not something that is, within the bounds of Proposition 22. So the other thing I would say in answer to that question is that even though there have been those that have tried to convince, say, the Department of Finance that that number is not right, I don't think they care. It's simply not been acknowledged that that analysis may be faulty and that there may not be that much money available. Next question. Would legal challenges also place a stay on the elimination of redevelopment agencies and diversion of tax increment revenues to the state until the courts hear the lawsuit? And Brent, I think you have a ready answer for that.
Yes, we would almost certainly request that the court issue a stay which would maintain the status quo until the lawsuit can be finally determined. Courts have discretion to grant that kind of a stay. The usual test is whether there is harm that would happen as a result of the law going into effect that couldn't be remediated, and the court also tends to look at the likelihood of success on the merits. We feel good about prospects of having a court issue a stay in this case if it becomes necessary.
So the short answer is, one, we would certainly pursue one. And we think the likelihood of it being granted is good. Next question comes from Visalia. Is the July 1st deadline a firm date by the state legislature, or do we anticipate legal action beforehand so RDAs can remain implementing our work? Well, first of all, the July 1st date was in the governor's proposal. We don't know whether that's still the date because we have yet to see that language. We don't know whether the legislature will approve such a date. We hope that the legislature will change its mind and say, no, we're not going to eliminate redevelopment agencies, we're going to keep them, and so thus we hope the July 1st date becomes irrelevant. So again, just kind of speculation there in terms of what that language is actually going to say. Now, next question. What is the status of the rumored retroactive proposal which may invalidate cooperative agreements and other recent RDA actions? Well, the first rumor on a retroactive date was that something was going to occur, I think, around January the 18th. Obviously, that never happened. We're not spending much time trying to chase rumors. We're spending all of our time trying to defeat this proposal. And we don't know of any sort of latest rumors on retroactive data. As I said earlier, we'll answer that when we see the language, hopefully today. Given the obvious legal strength, why even compromise with the state at this point in time? Chris, you want to tackle that? And I might chime in as well.
Sure. Let me just underscore, neither the League nor CRA have proposed any compromises. Prop 22 and Article 16, as Brent laid it out for us, really restricts our ability to offer anything that would require redevelopment agencies to turn money over to the state. It's just as crystal clear to us as it could be. So we're not suggesting compromise. We believe the law is clear. We believe the voters' intent is just as clear, and we're working to really ask the legislature to quit wasting time and to focus on the things that the Constitution clearly allows them to do and which they need to do, that this proposal is simply illegal, and that it will produce no funding for the state budget, zero funding for the state budget, because it's illegal.
Okay. Let me just add to that we should distinguish between just giving up money wholesale to the state and what we might describe as reforms, which are much more limited. I think we all need to recognize that there are complaints about redevelopment. For example, we've all seen complaints that housing money is not being spent as quickly as it should by some agencies, certainly by no means all. We need to acknowledge those kinds of complaints, and that we need to address them. And so we all can do a better job in terms of looking at where we can make our own operations better. The next question, should we remind legislators that California will be the only state in the United States to enact legislation that would eliminate local base reuse authorities and impede base reuse efforts supported by the U.S. Congress? We're talking about military bases here in California that are usually the subject of special legislation making them redevelopment project areas. And obviously, if that's a issue in your locale, sure, you should make that point to legislators so that they understand that is just one more consequence of eliminating redevelopment. Those base reuse projects are important, and they're important for the same reasons that we've been emphasizing throughout this campaign, which is that eliminating redevelopment is the same thing as eliminating jobs. We know that in good years, when you're allowed to do your jobs and the state is not taking your money, redevelopment supports over 300,000 jobs. It adds $2 billion of tax revenue to state and local coffers. It provides $40 billion of activity in the overall economy. Now, the state has tried to dispute those numbers. The state doesn't have any economic analyses that show differently. And so we're confident of our own methodology and our own research that verifies that those numbers are good numbers, and we're standing by them, and you should continue to emphasize the jobs qualities that come out of good redevelopment projects. Next question.